Yes, hi everyone. This video relates to concerns United States law, and if you are come from other jurisdictions, you should just bear that in mind. However, you're more than welcome to watch it and acquire something beneficial. Can the police, when they lawfully stop a car, can they search the car when they have smelled marijuana coming from inside the car? If they can't, can they search the driver? Or to make matters worse, can they search the passenger if they have not located the source of the smell of the marijuana? They don't know who is the person who smells, such as was the case of Humphreys, court where the police could smell the strong odor of marijuana coming from the suspect, so they could arrest him. However, could that happen if they cannot particularize the odor? Now, this is a very specific facts based video, and it does not really apply to all the cases where the police has probable cause to search a car based on drugs. It actually aims on breaking down the considerations uh, taken by certain jurisdictions, not all jurisdictions in the United States, when the police officer encounters this facts based scenario, the specific facts based scenario. We're talking about smell of marijuana coming from inside the car, and you are a passenger inside a car. Can he take away your liberties? Can he search you? Can he order you out of the car? Your passenger inside the car? Can he arrest you? Can he search you? Now, the United States Constitution states that everybody should be free from unreasonable searches and seizures in their own papers, houses, and effects. There has been case law which actually protected the rights of the passengers inside cars, and also of, let's say, persons that happen to be inside a premise. Also, when uh, there has been an investigation for drugs. This is, for example, the case of Ibarra versus Illinois. This is a United States Supreme Court decision, which stated just because a patron happened to be around, present, when the police had obtained a search warrant for narcotics of the barman, on the person of the barman and the place itself, um, the fact that he was there could not supply them with reasonable suspicion that he was armed and dangerous. Although it's very logical, very logical. Why should the person in Ibarra be any less armed and dangerous, being a person that happens to be at that point in time at the uh, at the time of the search for narcotics, right? And where there are only like a few, was a few number of people there, and when narcotics are widely considered to include chronically armed and dangerous individuals that have weapons and arms, and they will go to any length in order to protect their drugs because of the uh, gun activity that's rife in these kinds of situations. Any less than when this situation um, is actually found in a vehicle, in a car. Well, this is because, in my opinion, the court wants to maintain a balance, and it's also because of the automobile exception. Now, the car, when you are inside a car and you're a passenger, you have lower expectations of privacy. But still, you have lower expectation of privacy. But that was not the case in DeRay. However, DeRay did not involve drugs, so you can see that even though there may be generalized principles, you know, that you might have lower expectation of privacy, and then like uh, a car is suspected of um, criminal activity, um, though still being a passenger inside a car, you cannot be searched. However, if you are suspected, if you are a passenger inside a car and which is suspected of criminal of drug activity, because of the strong connection that drugs have with gang affiliation and drugs, right? You're more likely to be armed and dangerous. Now, a policeman in a good deal of jurisdictions, for example, Texas, see the case of Rocha, the state versus Rocha, see the case of um, state versus Allard, see the case of People versus Williams, which is Appellate Court of Illinois. See the case, for example, of United States versus Saki, which is a Court of Appeals case, and the case of People versus Collier. You'll see that when there is a smell of marijuana involved, and where there is in drug trafficking, then automatically the persons may be armed and dangerous. So the police has two avenues, right, that through which it can search the passenger. It may be even easier for them to search the driver because remember it's facts based, and because he happens to be a driver in the case, it's easier for him to be connected to the drugs. He might be hiding the drugs. He might have been using the car in order to deal drugs, and all these various scenarios that make him a lot more prone to a search than a passenger. The passenger is still protected by the case of DeRay, but this case involved counterfeit gasoline rations. It did not involve drugs, right? And second, so they could have searched him based on the fact that he could have been armed and dangerous. And second, it did not involve the smell of marijuana, which is something alive and something that could potentially implicate anyone to the exclusion of no one. Two avenues. You could be armed and dangerous, and because you happen to be inside a car as well, so you got a lower expectation of privacy. In contrast with the case of Ibarra, which concerned a premise, and that's very important. Location is key, and also based on probable cause to search the car and search you also, because you happen to be inside the car and you could be hiding the marijuana. So the still smell, and there's strong policy consideration in favor of searching you because since in those types of cases which involve smell of marijuana in cars, and since cars are widely used for um, individuals that engage in drug dealing and drug trafficking, to that they can pass on the weed to a passenger and run scot free from any search of the law based on the fact that the passenger can have passengers immunities based on the case of DeRay. So the passenger could hide the evidence on his person on behalf of the driver. So that's why I'm saying it's a very fact-based um, presentation. Also, in the case of in the case of Williams, this case was the passenger was searched. He invoked his Fourth Amendment constitutional rights to say I could not have been searched because the smell could not have been smelled on me could not have been located. Case of Humphreys, there needs to be an individualized probable cause, individualized suspicion. No, said the court. He invoked the case of DeRay. The court said no. In DeRay, what happened is that there was a man called Batista, and there was an informant. His name was Reed, and he had informed the police that he was going to be supplied by this man, Batista, counterfeit gasoline rations. We're not talking about drugs, we're not talking about smell. So remember, the source that gives rise to the probable cause to search the car in the first place. And the police followed him, and they approached the car. And when they approached the car, what did they find? They stopped them, and they find the informant holding the counterfeits and saying that he would, Batista had just supplied him with a counterfeit. So what they do, they arrest everyone, including the passengers, DeRay, and they perform an incident on DeRay's person, a search, incident, and arrest. Now they had two arguments at the Supreme Court level. One is that the search was lawful because it was based on a search incident to arrest. They found the drugs in there, and therefore they could arrest everyone. And second, that they could search the car. And since he happened to be inside the car, they could search him as well. Well, the court said no, that could not happen because he happened to be a passenger inside a car, and because the passenger inside a car, he does not lose his immunities from protection of the by the Fourth Amendment of the United States Constitution. Also, when the police obtained the information excluded the passenger. In contrast with the case of Williams, where the police was smelling the marijuana, it was still something that implicated everyone to the exclusion of no one. The information that the police had never implicated the passenger, never implicated DeRay. Furthermore, we're talking about counterfeit rations. So even if they wanted to search DeRay based on the fact that it was armed and dangerous, they couldn't do that. However, in the case of Williams, they could have also searched him and frisked him, even though the scope of the two searches may be different. The scope of a frisk is more limited in scope than the search based on probable cause. Now, a frisk is the outer garments. It's widely accepted that police can also hide underneath the garments if they know beforehand where the weapons are going to be. However, it's been kind of more extended. We're going to talk about it in another video, but we do not need to worry about that now. Two avenues when the smell of marijuana inside a car, can the police, through these two avenues, search a passenger, and that's what the most important. And in Williams, the court said, well, you know what, DeRay is not going to apply because it was reasonable to search the passenger because he could have been hiding the drugs on his person. And the smell of marijuana is something live. It cannot be compared to the rations. So, the case of Saki now. It's a case of Saki. It's a Court of Appeal decision. I have included the link below in this video so you can click on it and you can see the case for yourself. And it states that the Terry stop, it basically examined the question whether, for the second avenue, remember, not probable cause to search the car which extends to the passenger because of the smell of marijuana, but because he may be armed and dangerous. And it actually examined the question whether the police can search someone inside a car when drugs are involved because he may be armed and dangerous, and where the police has reasonable probable cause to suspect that the drug is implicated in drug activity. There's evidence of drug activity in there. And he said, yes, given the staggering numbers, almost 30% of homicide rates are happen during stops that are concerned with drug investigations, and when there's probable cause to believe there's drug activity going on. So there is, on the one hand of the scale, the individual rights that are protected through the Constitution. They are constitutionally protected individually. And on the other hand, there is the public interest for the the fight of crime, and officer safety is included in this interest. And of course, every policeman, when there's drugs involved in his right mind, is going to at least pat someone down, pat the passengers down, because outside of all the general principles, there's drugs involved, and they are inside a car, and we all know how dangerous these individuals can be. They carry weapons as part of the daily life in order to protect their merchandise, which is the drugs that they have, not only from police officers, but also for against other drug dealers and against other individuals that engage with this sort of activities. Usually, the ruthless criminals, so they will do anything to avoid being detained by the police, and they will draw the guns if they have to. They're inside the car, so they can be ordered out, including the passengers, right? Including the passengers, because the passenger can easily have a gun inside the car. They can search the car. They can perform a protective search as well inside the car, because it's easy in the immediate area of the driver and the passenger to draw a gun and kill the policeman. It's as simple as that. There's nothing beyond that. However, according to Terry, there still needs to be an articulable suspicion, the totality of the circumstances, that the passenger is armed and dangerous, if not the driver, because the driver is more easily implicated since he happens to be the driver of the car, let's say. In this case, the court in Saki said that if there are no circumstances or factors that allay the suspicions of the police officer that he may be armed and dangerous, the passenger, then he can pat him down. Now, still, there might be a theoretical apprehension of a reasonable suspicion. You need to adduce that in the form of evidence, either oral evidence or whatever other evidence. Mostly, it's got to be oral evidence at court in order to justify the pat down, because there's still this constitutional protection. However, we see that because of the facts of the case, it has been narrowed down. The threshold has lowered, and the policeman just needs to find factors that allay his suspicion. Now, there have been standards and factors, if not the combination of smell and a car cannot be considered a factor on its own to pat someone down for drugs. If that cannot be considered, which is strongly considered based on the cases, based on the case law, loose clothing, or the number of police officers on the scene, the number of passengers in the scene, painted black windows. Um, they all have been held to be, even also the physical build of the passenger inside the car, the driver inside the car, that can overpower the policeman any point, any given point, have been held considered to be factors that um, affect the decision of a policeman to pat down a passenger when there are drugs involved. So a very low threshold again, um, because of the heightened likelihood of passengers to be armed and dangerous and gang affiliated, and gangs have guns as well for the majority of the cases, and knives inside the car. And also, it's more likely for someone to have a gun hidden inside a car, in the interior of a car, right, instead of having it on him and walking down the street at any given time. It could be just my opinion, but I'm saying this presentation is not an authority of the law, but there's no easy answer to that. But it gives you a more practical approach to what the police officers are allowed to do. Let's say um, on the um, contours of the law. What could be the scope of the search when there's probable cause to search a car for drugs? What is the scope of the search? The scope of the search is that the police can search all the belongings inside the car when they reasonably suspect that drugs may be involved, regardless of the ownership of the the of the belonging. So as long as the object of the purpose is satisfied, and that's to find the drugs, and that's considered reasonable. There is also the case of State versus Grande. It's a Supreme Court of Washington State which uh, said that a passenger cannot be arrested or he could not be searched because an individualized suspicion needed to be present, and when the smell cannot be detected on the person of the passenger, he was immune from the search. As simple as that. So the search was unconstitutional, and therefore the evidence was stamped out of the poisonous tree and was suppressed and could not be admitted in a court of law. The government, of course, stated that in confined places, and as other case law and Texas case law states that when there are confined places, such as a car, for example, uh, the number of people that might have been smoking or possessing the drug or dealing the drug, and there's male in a confined place, it actually significantly narrows down. So there is more of a suspicion that they will be smoking the drug or hiding it on behalf of someone else, and there's not that much of an inconvenience based on just trying to search everyone inside a shopping mall because there's no marijuana. That's more unreasonable. So those are the kinds of yardsticks that the courts use in order to interpret and apply the U.S. Constitution, reasonableness, and all these different factors. And it said no, based on Hammond should be overruled because it came before Ibarra. But Ibarra considered a premise, right? And as we all know, the automobile exception does not apply. And there is also a case, Bronson versus the state, which actually states that the passengers inside a car can be arrested when there's smell of marijuana coming from inside the car. So it goes as far as allowing the police to arrest someone. So even though there are the cases of Ibarra, there are the cases of the Ray that protect the passenger. There still seems to be a strong sentiment, which, we like it or not, applies to courts even at an appeals level around the United States, and gives powers to the police when they encounter drugs and smell of drugs inside a car, right, to search a passenger, even though it has nothing to do, and there's no independent, he's no independent, not independently connected, right, with this uh, smell. There's also the criminal enterprise principle. For this to apply, there need to be actually additional factors that can be taken into consideration. For example, the sight of drugs and inside a car, nobody claims, you know, nobody claims the drugs, nobody claims possession of the ownership of the drugs, and certain other circumstances, additional factors raised. So I just wanted to give you a review of the opinion of uh, of the courts in various jurisdictions when these facts are considered. This information is not judicial authority. You're free to make your own search because it's very, very fact based, and it can change from from day to day and minute to minute. It's those cases are very fluid, and they depend on very certain facts. So this is not legal advice; it's simply educational. Please subscribe to my channel for more videos like this. Thank you very much.